impact, particularly on Indian economy. Such attempts to create an environment suitable to the changing times have to be appreciated by the judiciary, of course, by suitably interpreting the constitution and the laws. But by there being a paradigm shift in the economy of the country, akin to perestroika in the erstwhile USSR, in my view, neither the judgments of the previous decades nor the judges who decided those cases can be said to have done a disservice to the Constitution. The answer lies in the obligation that this court in particular and the Indian judiciary in general has in meeting the newer challenges of the times by choosing only that part of the past wisdom which is apposite for the present without decrying the past judges. I say so, lest the judges of posterity ought not to follow the same practice. I say that the institution of the Supreme Court of India is greater than individual judges who are only a part of it at different stages of history of this great country. Therefore, I do not concur with the observations of the learned Chief Justice in the proposed judgment referred to above. I say so for the following narration. In paragraph 229, His Lordship, the Chief Justice, has given his conclusions. My opinion relates to conclusions in subparas D, E, and F. And I am also stating a few making a few observations on Raghunatha Reddy, Sanjeev Kok, Abu Kavur Pai, and Basanti Pai. My immediate answer to the aforesaid conclusions is that material resources can, in the first instance, be divided into two basic categories, namely state-owned resources and privately owned resources. There can be no contra-opinion to the fact that all state-owned resources, that is, resources which belong to the state, are essentially material resources of the community which are held in public trust by the state. However, with regard to the material resources which belong to the private owners, how do such resources get qualified as material resources of the community? In my view, a privately owned material resource can be transformed and can indeed acquire a status of material resource of the community. What are the material resources owned by a private person which can be material resources of the community? In my view, they would not include what can be termed as personal effects of an individual, such as movables in the form of an individual's apparel, household articles of daily use and need, such as furniture, personal jewelry, kitchenware, and such other articles. These are articles which are of daily need and use. Then I have given what is the meaning of personal effects. This would generally mean such tangible property as is worn or carried about the person, or the designate articles associated with the person as property having more or less intimate relation to a person or possessor of such tangible property as attend. This is what Mr. Rakesh Dwivedi has argued, and I agree. However, I must elaborate on the proposed judgment on the legal distinction between how a private resource qualifies as one of the community and how such a resource is subsequently distributed to subserve the common good. It is on this crucial point that I have penned my separate opinion. Then the five features of Article 39B, His Lordship, the Chief Justice, has extracted. I have elaborated on that. How do material resources which are privately owned become material resources of the community? The answer to this question lies in the legal devices that are adopted by the state to transform private material resources into material resources of the community. This could be inter alia in the following 5 ways, which are illustrative and not exhaustive in nature. 1, by nationalization. 2, by acquisition. 3, by operation of law, such as vesting of private resources in the state. 4, by purchase of material resources from private persons. And 5, by the owner of the material resource converting as a material resource of the community by donation, gift, creation of an endowment, or a public trust. What is the common denominator in the methods adopted by the state for converting private material resources into material resources of the community? In all these 3 devices at 1, 2, and 3 above, what is of significance is that when, by a process of nationalization, acquisition, or vesting of private resources in the state occurs, there are certain legal processes which take place. The first process is to convert the private resource into a resource of the community by vesting in the state. And the second process is to utilize these community resources for the purpose of distribution for the common good. Distribution could be in two ways. Firstly, by actual distribution to the deserving and eligible persons as per the policy to be implemented. Second, the state could retain ownership and or control having regard to the nature of the resources and other relevant factors. The third process is that the private owners of these resources are fairly compensated when they lose all rights, title, and possession over such resources when it becomes a material resource of the community. Then I have gone into the details of Ranganatha Reddy, then Bhim Singh Ji in Sanjeev Kok. I'll say a few words on Sanjeev Kok and later Basanti Bai. In Sanjeev Kok, in this case, the Constitution bench arrived at its conclusions on the validity of the Coking Coal Mines Nationalization Act 1972 and upheld the same. But while doing so, in paragraphs 10 to 14, observations were made with regard to the judgment of this court in Minerva Mills. In fact, paragraph 10 reads as follows, quote, "We have some misgivings about the Minerva Mills decision, despite its rare beauty and persuasive rhetoric," unquote. In my view, those observations were wholly unnecessary as they lose sight of the outstanding judicial statesmanship exemplified in the majority judgment authored by Justice Y.V. Chandrachud, Chief Justice in Minerva Mills. One has to bear in mind the fact that the hearings in the case of Minerva Mills as well as in Vaman Rao were proceeding contemporaneously but before different benches, both headed by learned Y.V. Chandrachud, Chief Justice. Realizing the import of the separate opinion of Justice Krishnaiyer in Ranganatha Reddy and the likelihood of the said opinion gaining momentum in Minerva Mills as well as in Vaman Rao, and rightly so, the then learned Chief Justice took upon himself the responsibility of pronouncing the operative portion of the judgment in Minerva Mills in May 1980 and supplementing the reasons in July 1980. And the judgment in Vaman Rao was delivered in November 1980, just prior to the retirement or demitting office of Krishnaiyer J. It is another matter that Justice Bhagwati frowned upon such a strategy adopted in Minerva Mills and in fact penned a common separate judgment in Minerva Mills and Vaman Rao, although the issues were distinct, though overlapping in certain areas, which were minority opinions. In Vaman Rao, only a short order was passed by Justice Bhagwati. Justice A.N. Sen, by his concurring judgment, however, opined that since there was a review of the judgment in Minerva Mills pending before this court, he refrained from dealing with the said decision and from making any observations or comments on the same. This is with regard to the interplay between Minerva Mills and Sanjeev Kok. Basanti Bai. In this case, the court considered the correctness of the judgment of the Bombay High Court, by which the High Court had declared subsections 3 and 4 of the MADA as void and had given certain ancillary directions. This court at the outset proceeded to observe in para 13 of the judgment as, quote, "We shall proceed to test the validity of the argument, keeping aside for the time being the observation in Sanjeev Coke Manufacturing Company versus Bharat Coke Coal Limited. The question whether an act is intended to secure the objects contained in Article 39B or not does not depend upon the declaration by legislature, but depends on its contents. Reference was made to Ranganatha Reddy, which dealt with the question whether nationalization of bus transport was covered by Article 39B, and to Justice Krishnai's observations only in a limited way. It was observed that MADA was protected from challenge owing to the applicability of Article 31C of the Constitution, and it was immune from the challenge under Articles 14, 19, and 31 of the Constitution. It was further observed that land ceiling laws providing for acquisition of land for providing housing accommodation, laws imposing ceiling on urban property, etc., cannot be struck down by invoking Article 21 of the Constitution. Consequently, the judgment of the High Court was set aside to the extent that subsections 3 and 4 of sections 44 MADA had been held unconstitutional and struck down, and the appeal was allowed. What is significant about the judgment in Basanti Bai is firstly, the case was considered in light of only that portion of the judgment of Justice Krishnaya which dealt with the aspect of distribution and did not discuss other aspects of Justice Krishnaya's opinion, which dealt with the judgment, which dealt with the question whether even private property can be equated as material resources of the community. Secondly, in this judgment, it has been expressly stated that to test the validity of MADA, the observations of this court in Sanjeev Kaur were to be kept aside. Justice Venkatramaya, who is the author of the judgment in Basanti Bai and a member of the five-judge bench in Sanjeev Kaur, distanced himself from the observations made by Chinnappa J in Sanjeev Kaur, as well as the other observations of Krishnaya J in Ranganatha Reddy. However, what is common in all these cases is the fact that nationalization of contract carriages in Ranganatha Reddy, nationalization of coal mines in Sanjeev Kaur, and reservation of land for public amenities under MADA were all upheld and sustained on the touchstone of Article 39B and protected from attack by virtue of Article 31C. While Justices Krishnaya and Chinnappa supported their reasoning on the touchstone of the word socialist in the preamble of the Constitution, Justice Venkatramaya and Basanti Bai considered the validity of MADA, rehorsed the observations made by Justice Chinnappa in Sanjeev Kaur, and selected only certain portions of separate opinion of Justice Krishnaya in Ranganatha Reddy. Thus, this court was able to consider the validity of MADA on the strength of Articles 39B, read with Articles 31C, without taking note of many of the observations in Ranganatha Reddy and no observation in Sanjeev Kaur made by the learned judges on the basis of their socialist philosophy and on socialism. Basanti Bai is a judgment which was delivered in the year 1986 when perestroika was taking place even in a country such as United Union of Soviet Socialist Republic, the home to socialism. And there was also a beginning of a new thinking in India too, commencing with 5 technological missions leading to the reforms of 1991, which I have discussed in the earlier part of my opinion. Then I have given my because it's as usual, my judgment is very long. Therefore, for a clearer understanding, I have given a summary of my conclusions and my views of the conclusions of the Honorable the Chief Justice. As already said, I am agreeing in the first part and I have elaborated on the second part. Then I say what's significant is that the judgments in Ranganatha Reddy as well as in Sanjeev Kaur upheld the respective nationalization acts. Therefore, on merits, it cannot be held that Sanjeev Kaur violated judicial discipline. One cannot lose sight of the fact that in Sanjeev Kaur, this court did not decide the case only on the basis of the opinion of Justice Krishnaya in Ranganatha Reddy, but on merits on the validity of the Nationalization Act. Therefore, Sanjeev Kaur is good law insofar as the merit of the matter is concerned. And I have said privately owned resources except personal effects as explained above can come within the scope and ambit of the phrase material resources of the community, provided such resources get transformed as resources of the community as discussed above. To reiterate, it would not include personal effects as discussed by me in paragraph 7.6. In my view, the judgments of this court in Ranganatha Reddy, Sanjeev Kaur, Abu Kaur Bai and Basanti Bai correctly decided the issues that fell for consideration and do not call for interference on the merits of the matter as explained above. The observations of certain